it is a desire to continue perpetuating a falsehood rather than a desire to expose and vindicate the truth that underlies Venezuela's hostility to the court hearing Guyana's claims. Instead of proceeding to determine the merits of Guyana's claims, Venezuela urges the court to decline to exercise jurisdiction so that the dispute between the parties could instead be resolved through a process of negotiation. By making that argument, Venezuela once again invites the court to condemn the parties to perpetual deadlock.
That was Carl Greenidge, Guyana's agent in the border controversy case before the International Court of Justice and a former Minister of Foreign Affairs. As he presented before the World Court in Hague, Netherlands on Tuesday, he underscored that Venezuela has been pursuing several actions that effectively stall the adjudication process that could fully and finally settle the border controversy between Guyana and Venezuela. This was evident, he said, during the Spanish-speaking country's objections before the ICJ. Greenidge believes that Venezuela does not want the World Court to preside over the matter because this will validate the 1899 arbitral award which set the boundary between the two countries and prove that Essequibo does belong to Guyana. Before Greenidge offered his closing statements, members of Guyana's legal team, Professor Pierre Dargent and Professor Philippe Sons, stressed that much of Venezuela's arguments before the court were without evidence. The Spanish-speaking country raised preliminary objections that halted the adjudication process in the border controversy. It argued that the United Kingdom should be a party to the border case given that the British government was party to the 1899 arbitral award that determined the land boundary. It also posited before that tribunal and those involved in the 1899 award may be compromised or engaged in some misconduct. Additionally, Venezuela's Professor Paolo Palchetti on Monday said that the United Kingdom engaged in coercion and corrupt practices in relation to the 1899 award. Guyana's legal team continued to disagree with these arguments and said that the World Court could aptly investigate such claims while presiding over the substantive border controversy case.
Venezuela has no good answer to the proposition that by signing the Geneva Agreement, the United Kingdom has explicitly expressed its consent to the court exercising jurisdiction over Guyana's claims which have been brought pursuant to that agreement. And finally, this conclusion is fully confirmed by the various statements that have been made by the United Kingdom and to which we drew your attention last week. Statements made in the period after the signing of the 1966 agreement and, very much more recently, in the period after the court gave its judgment in December 2020. And once again, Venezuela offered you, the court, no alternative interpretation of these many statements.
With oral arguments on the preliminary objections filed by Venezuela completed, the World Court will issue a judgment subsequently. That judgment is expected to detail whether the ICJ believes it should preside over the claims brought by Guyana. For context, however, in December 2020, the ICJ already ruled that it has the jurisdiction to hear the case. Reporting for the newsroom, I am Vishani Raghavar.